All right. Good morning, everyone. We still have some people logging on, but we will go ahead and get started. Welcome to everyone, and thank you for joining us for our webinar, What's on the Horizon in Employment Law. Next slide, please. My name is Julia Rust, and I am a partner in Williams Mullen's litigation practice, where I help companies navigate a variety of matters ranging from contract disputes to business breakups. I am delighted to be joined by Toy Hunter, Vice President of Business Retention and Expansion at the Hampton Roads Alliance, and she will provide an overview of the Alliance for us. I'm also joined by my colleague David Burton from our Labor, Employment, and Immigration practice, who will summarize several key labor and employment developments today. Next slide. We have an action-packed agenda for you guys, starting with an overview of the Hampton Roads Alliance. Then we will pivot to employment and labor law under the second Trump administration and Virginia state statutes. We will conclude with a brief Q&A period if we have a few minutes. Next slide, please. Just some quick technology notes before we get started. You can submit questions by using the Q&A feature in Zoom at the bottom of your screen. We'll answer your questions at the end of the presentation, time permitting. For assistance with any audio or technical issues, please use that same Q&A button, and our team is behind the scenes and ready to assist you. We will also be sending the materials and a link to the recording out after today's presentation. Next slide, please. And now I would like to ask Toy Hunter to provide an overview of the Hampton Roads Alliance for us. Welcome, Toy.
Hi, Julia, and thank you. We can go to the next slide that gives an overview. I'm Toy Hunter, the Vice President for Business Retention and Expansion here at the Alliance. And I'd like to take a moment to introduce you to the Alliance and how we support the businesses across the region. As the Regional Economic Development Organization for Hampton Roads, the Alliance is dedicated to fostering business growth, investment, and job creation for the 15 municipalities that we represent. The Alliance is supported by those localities and over 100 private sector investor organizations. While much of the work that we do is focused on attracting new businesses, we're equally committed to supporting the success of companies that are already here. Through our business retention and expansion efforts, we work closely with local economic development offices, industry leaders, and workforce partners to ensure businesses have the resources they need to thrive. Whether it's assisting with expansion plans, talent development, navigating incentives, or connecting companies with key stakeholders, our team is here to help businesses grow and succeed. Additionally, we help to advocate for policies that enhance our business climate and position our region for long-term prosperity. We understand that when our existing businesses are strong, our entire economy benefits. At the Hampton Roads Alliance, we don't just bring businesses here, we help them stay, expand, and lead. So if your company needs support, we're here to connect you with the right resources and opportunities. That's why we're excited to partner with Williams Mullen to bring you this presentation and look forward to the relevant and useful information that will be shared on this webinar. Thanks for your time and attending today.
Thank you, Toy. We are thrilled to be partnering with the Hampton Roads Alliance on this webinar, and we appreciate all that you guys do for the Hampton Roads community and those resources that you provide. Next slide. Next up is my colleague, David Burton, a partner in Williams Mullen's Labor, Employment, and Immigration practice. He also serves as the firm's regional managing partner for Hampton Roads. Welcome, David. We look forward to hearing your updates today.
All right, well, thank you all for having me today, and thank you, Toy and the Alliance, for partnering with us to do the presentation. Well, let's start off with probably the issue that is most people are reading about and hearing about, and that is, what is the status under the Trump administration and the federal government with DEI initiatives? It's been a very interesting several months. And I want to give a little bit of background and history before I talk about what's going on right now with the administration. Most of you who have, especially if you're a federal government contractor or have any business with the federal government, you are used to dealing with affirmative action plans, dealing with the idea of having diversity, equity, and inclusion programs. Under President Biden's administration, there was a huge emphasis on having many of the federal government agencies involved in DEI programs, encouraging employers, both government contractors and non-government contractor employees, encouraging them to get involved in the DEI effort, having DEI programs, saluting those issues. Immediately upon President Trump taking office, he started a campaign of issuing executive orders related to diversity, equity, and inclusion programs, both within the federal government and also in the private sector, whether or not you were a publicly traded company or not a publicly traded company. Many of our public sector clients have DEI programs, and they have worked very hard on those programs. One of the most important things that President Trump did with his executive orders is he issued an executive order that suspended President Lyndon Johnson's executive order 11246. Many of you if you are a government contractor, are familiar with that executive order. That executive order is the one that created a situation or the scenario where if you are a federal government contractor or a subcontractor, there's flow down requirements under these contracts. If you are a federal government contractor or subcontractor, you were required under this executive order to take steps to create, maintain, and update affirmative action plans. And the purpose of those plans was to ensure that you would, I'm sorry, my phone is ringing despite the fact that I'm muted. You would create these plans so you could hope to prohibit discrimination in employment based on race, color, religion, national origin, and then in a 1967 amendment, sex discrimination. So how did that play out for federal government contractors? You were required, while you were involved in federal government contracts, to maintain applicant data logs. So when people would apply for a job, you were required to gather information the best you could as to the sex, color, religion, race, national origin of those applicants, and you were required to maintain that information for a period of time. You were also required to put together plans that took your community and your workforce that was available in the community and strive to create situations where you could help minorities progress, be hired, be involved in your company. Well, with the suspension of President Johnson's executive order, those programs are in limbo and have kind of been shut down at this point. The Office of Federal Government Compliance Programs, so if we go to the next slide, Office of Federal Government Compliance Programs, which oversaw these affirmative action processes, they're really somewhat without a mission right now. President Trump nominated a head of the Office of Federal Contract Compliance Programs this week. That individual's job, once they get in, will probably be more not to focus on whether you are creating these plans, but are you making opportunities available to all applicants, and are you hiring the most qualified applicants? The Office of Federal Contract Compliance will still be able to look at and enforce federal government contractors' compliance with the Americans with Disabilities Act when it comes to employment. So you will still have those obligations, and also your Vietnam veterans reporting obligations. and many of you are familiar with that, but you are trying to create situations where you can hire Vietnam veterans. You're keeping applicant flow about that. Now, of course, at this point in our history, uh, the number of Vietnam veterans applying for jobs is becoming fewer and fewer. Within the next 5 to 10 years, probably there will be no need for that Vietnam veterans requirement, but it is still out there. Now, I do want to caution people and just kind of give you an example. There are some state agencies out there, not necessarily Virginia, but I can tell you I've had this happen with me in North Carolina. They are still, with their state programs, still asking employers to comply with Executive Order 11246. We'll see how that plays out, but I did have a case recently down there in North Carolina where a client of mine who has a big state contract had to go through an audit, and the state of North Carolina was looking for such information, and we had a very interesting discussion and exchange with them. They told us they still wanted us to keep that information and report on it. So we will see what happens. I would encourage and stress to everyone to not necessarily lock up these programs or throw them out. There are going to be court challenges. There already are some court challenges. We will see what happens. But right now, it is a little bit of an interesting territory. All right, let's go to the next slide. The U.S. Equal Employment Opportunity Commission is going to have a very different focus now than it has in my entire history of practicing in this area, which is 32 years at this point. Again, there's not going to be a strong emphasis at the EEOC level on, are you engaged in certain types of discrimination? The EEOC is looking heavily now, and their general counsel has issued guidance that they are very interested in looking at reverse discrimination cases. So there will be an emphasis at the EEOC at looking at why are non-minorities not necessarily getting a job, especially in the hiring area, or why are they being laid off in a greater proportion perhaps than others? Are they the least qualified, or is it some other issue? There has been guidance issued by the U.S. Equal Employment Opportunity to their field offices on how to investigate those cases, and basically an assignment to those local offices to go and find those cases so that the EEOC can start to litigate them and try to create precedent in the courts on the issue. The current administration wants to change the law in that area. So we will have to wait and see what happens there, but that is going to be a very interesting process for folks. One of the most interesting and closest to the hearts of law firms, especially people who are involved in managing law firms, is the EEOC has sent out letters to numerous law firms, very large law firms at this point, and to some large publicly traded companies, telling them they want all the data that those companies have on their DEI programs going back to 2019. The reason for those requests, they haven't specifically stated, but it is likely so that they can look at reverse discrimination trends. Now, if you were to get one of these letters, you should call your lawyer as soon as possible. Whether the EEOC actually has the ability to enforce such requests is a big question, but they are out there trying to do that. Next slide, please. Two other areas that we're going to see a lot of change probably at the EEOC is going to be in the sexual harassment arena and in pregnant workers arena. Many of you will recall that last year, after a long process and comment period, the EEOC issued guidance in August of last year on sexual harassment cases. And while that guidance isn't necessarily the law, it is something that the EEOC uses when they investigate cases and when they prepare cases they plan to litigate. While the memo was not that different from what we see in court cases involving sexual harassment, there were some interesting areas in which the EEOC, at least as of last year, had a much more expansive view than where the courts were. The EEOC was very interested in bullying and microaggressions. I suspect we are going to see this guidance, even if it doesn't get changed, get watered down in its application, and things like bullying or microaggressions alone are not going to rise to the level of actionable sexual, racial, whatever it may be, harassment in the workplace. Also, what is a tangible job action for purposes of your sexual harassment defenses? Again, if an adverse job action is taken against a person, there could be strict liability for the company. I think that is going to be a much higher burden for someone in the EEOC investigation phase to get through. If you have an employee who quits because they believe they have been harassed and then try to claim that they were constructively discharged and that was the tangible job action, that's already a high burden, but it's going to be a much higher burden now, I think we will see. Also, last year, the EEOC came out with their regulations on the Pregnant Workers Fairness Act. Whether those regulations will actually get changed, I don't know, but I suspect the interest that the EEOC has in looking for those types of cases will probably take a back seat to their interest in reverse discrimination cases. So plan to see some changes there. All right, next slide, please. All right, let's go now to the United States Department of Labor. During the President Biden administration, there were two large sets of regulations that the U.S. Department of Labor worked on. First of all, the Wage and Hour Division of the U.S. Department of Labor spent a large amount of time working up regulations as to the salary basis level for an individual to be exempt employees. That statute got it, or that regulation got enjoined on a nationwide basis out of the federal district courts in Texas, and there was some litigation ongoing up to the circuit courts as to whether or not they should be stayed or enjoined. The current administration has pulled those litigations. They are not fighting against that injunction now. So those regulations are dead. Whether the Trump administration decides to come up with their own regulations, we'll wait and see. But the ones that everybody was worried about last year are dead. Independent contractor regulations. They are also going to be revisited. Right now, because we are in Virginia, most of us, we have a state statute that requires us to comply with it. And that statute is actually, pollen is a little bit more expansive than the U.S. Department of Labor regulations. So if you are complying with the Virginia statutes, you will be complying with any federal regulations, but expect to see those change and expect it to be a little bit easier on the federal level for an employer to argue, or for a workplace to argue, that certain people are independent contractors as opposed to employees. Next slide, please. National Labor Relations Board. There's going to be big changes there also. A lot of you are familiar with the National Labor Relations Board, not necessarily because you have a labor union, but because you may have some employees who believe they have engaged in protected concerted activity, and they have rights under the National Labor Relations Act to engage in those types of activities. And you violate the law if you discipline or retaliate against people for exercising those rights. Three big areas we're going to see changes. The idea of quickie elections that the Biden administration really went hard at. If somebody wants to organize, if union wants to organize a workplace and force an election, that's still going to happen. That's the law. But the idea that those elections will happen in 2 or 3 weeks, that won't be the case anymore. It's probably going to be back to a normal routine of 6 weeks to 8 weeks, where the employer has more opportunity to engage in counter-organizing efforts. During the Biden administration, there was a huge push to eliminate in the workplace, despite the fact that the statute was amended in the 40s to add that free speech right because of some previous Supreme Court cases. The board during President Biden's administration issued some decisions that limited the employer's free speech rights and options in the workplace. Those will go by the wayside. It might take a couple of years, but the investigation at the NLRB and active prosecution of those types of issues will fall by the wayside very quickly. There was also what's called the CEMEX decision during the Biden administration that changed the burden on elections, meaning that not only it used to be that the employer had the right, if the union came to them and said, we have a majority of your employees who wish to be represented, will you let us represent them? Employers often said, 99% of the time, no, go file a petition for an election with the NLRB. The CEMEX decision flipped that and said, if the union comes to you, employer, and says, will you recognize, you either have to recognize immediately, or if you will not recognize them, then you have to file the election petition. And if you don't, you violate the law. That case is up on appeal to the Sixth Circuit. I suspect what's going to happen there is the administration will tell the Sixth Circuit they are abandoning their position, and they, don't want the case to go forward because of that. And very soon that decision will go by the wayside. Next slide, please. All right, well, let's talk about the Virginia statutes. As of Monday, I thought we were going to have some really interesting statutes to talk about. Go ahead. Next slide. With bipartisan support for the second year in a row, there were 2 statutes passed by the Virginia General Assembly. One was a paid leave, sick leave statute, and it would operate basically in accordance with the Virginia Employment Commission. Every paycheck an employee had, there would be deductions, both an employer portion and an employee portion, to go into a fund at the Virginia Employment Commission. And then if I am an employee and I have a triggering event, basically under the FMLA, the same FMLA triggering events, I would be able to go, if my employer didn't have a paid sick leave policy, I would be able to go to the VEC and get pay while I was out sick. The governor on Monday vetoed that statute, so it will not go into effect this year. Second year in a row that has happened. The other thing was there was a statute passed to raise our Virginia minimum wage up to $15 an hour by January of 2027. The governor also vetoed that. I point these statutes out because I think they are coming. There will be a day in the short term where we will get these statutes in Virginia. Now, a lot of you already have paid leave. If you have a paid leave policy that is more favorable than the Virginia statute, and that statute gets passed, you're not going to have to worry about it. But if you don't have paid sick leave under the FMLA, this will likely come, presuming that the Democrats hold the General Assembly. Once there is another Democratic governor in Virginia, if and when that happens, these statutes will get amended. The big thing I would point out as to the minimum wage statute is when that time comes and there is, enough bipartisan support, or you have the Democrats controlling the General Assembly and the governor's office, I don't think we'll be talking about a $15 per hour minimum wage. I think it will be a higher minimum wage. And while many of you may be paying more than that as the starting pay for people or people in hourly positions, there will be the wage compression problem, and it will cause another wave of more than, let's say, $17 an hour. So all these things are going to be coming to a movie theater near you soon, so you'll be able to watch it play out. All right, that is my presentation. I am happy to take questions.
All right, if you have any questions, ladies and gentlemen, you can submit them in the Q&A box. I don't have any come through. David, I did have a question for you since we've got about 2 minutes left. With respect to the discussion on the EEOC and the focus shifting to more of a reverse discrimination enforcement, what are some things that employers should be looking out for to set themselves up for success? And is it retroactive to prior hiring decisions, and should they be changing any internal hiring policies?
So your best approach right now as to any hiring decisions would be you hire the most qualified person for the job. You're not under the current administration. If you do that, and you can provide a subjective basis as to why you believe that person was the best qualified, you're going to be fine. But if you are engaging in disciplinary decisions and the person who always gets disciplined is the non-minority and minorities don't get disciplined, that's going to be a problem. I hate to say this, but if you have DEI programs and you still have them, and you are going, very aggressive on those policies or those programs, you just need to be aware that you are going to be potentially under a microscope. And so anything that reflects that you are trying to favor one group over another might be a potential problem. That we can have a long debate about the importance of those programs, and they are very important in many ways, but it's going to be a different agenda right now.
All right, thank you, David. If anyone else has any other questions, feel free to submit them to any of our email addresses, which are on the slide right now. We are happy to get back to you separately with answers to those questions. We are at 12:30, so I will go ahead and wrap this up. We so appreciate you all joining with us today. David, thank you for providing such helpful information. Toy, thank you so much for joining us and all the work that the Hampton Roads Alliance does for our region. Thank you, everyone, and we hope to see you soon. Bye-bye.
Have a great day, everybody.